view of the above discussion, the following are the conclusions. A. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the instrument of accession and the issuance of the proclamation dated 25 November 1949, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. B. The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. C. The exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. Once a prima facie case is made, the onus shifts to the Union to justify the exercise of such power. D. The power of Parliament under Article 356(1)(b) to exercise the powers of the legislature of the state cannot be restricted to lawmaking power, thereby excluding non-lawmaking power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. E. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. F. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370 Clause 3, which empowered the Constituent Assembly to make its recommendations, ceased to exist. It did not affect the power held by the President under Article 370 Clause 3. G. Article 370 cannot be amended by exercise of power under Article 370(1)(d). Recourse must have been taken to the procedure contemplated by Article 370 Clause 3 if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of CO 272, by which Article 370 was amended through Article 367, is ultra vires Article 370 Clause 1, Clause D, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. H. The exercise of power by the President under Article 370(1)(d) to issue CO 272 is not mala fide. The President, in exercise of power under Article 370 Clause 3, can unilaterally issue a notification that Article 370 ceases to exist.